Okay, I'm back now. I think I see the virtual background.
That's fine. You're welcome, madam.
Thank
We're
you.
waiting for our attendees to join.
Is it just me or is showing upside down on my
No, it's
background?
fine. It's fine. It's fine. That's fine.
Okay.
Yes.
Okay. So, Raymond,
Yes.
by the agenda, are you saying anything before I give the welcome address?
No, so what will happen is that B will continue playing the video and then allow the room to be populated a little bit. By the time I have maybe 50 people or thereabout, then you can just indicate that you're ready to do the welcome address. So you can do the welcome address and then introduce me as the moderator, then I'll take over then.
Okay. Okay. All right, no problem. So we have a lot of people waiting already, right?
Yes.
About 20 participants. Okay. Hi, Mr. Altaf. Do we have Mr. Ayemibo on the call as well?
Yes.
Okay.
Everyone's here.
Okay, so I just need.
For Rodrigo, it's 6 a.m. where he is.
Yeah.
He's running on very early morning.
Yes.
I hope you've had coffee at least.
Thank you for keeping up with our time zone.
No worries. No worries.
Interestingly, we're expecting people from around different continents to join in. So it will be around the same time for some of our listeners.
Yeah.
Good day, distinguished guests, colleagues, and friends. On behalf of AELEX partners, I'm delighted to welcome you to our International Trade webinar. My name is Rebecca Ibuku. I head the International Trade Practice Group at AELEX, and it is my honor to open today's session as we continue our tradition of fostering thought leadership and meaningful dialogue on critical trade issues across Africa and beyond. Since the inception of the AfCFTA, we have witnessed remarkable shifts in the landscape of cross-border commerce. Each year, our webinar serves as a platform to explore these changes, share insights, and equip ourselves with knowledge needed to navigate the evolving world of international trade. This year, Incoterms and international trade, navigating risk, responsibilities, and cost in cross-border transaction is our topic, and it could not be more timely. As businesses expand their reach and engage in increasingly complex transactions, understanding the nuances of Incoterms is essential for managing risk, clarifying responsibilities, and optimizing costs. We are privileged to have with us today a panel of esteemed experts who will share their perspectives and practical guidance on these vital issues. I encourage you all to engage actively, ask questions, and make the most of this opportunity to learn and to connect. In the course of the webinar, we will share some polls to also receive feedback and perspectives of the esteemed attendees. There will also be a segment for questions to be answered. I therefore encourage you all to please send in your questions or comments using the Q&A menu, and our moderator will deal with them as we progress. Once again, I thank you for joining us, and I wish you all an insightful and productive session. I'll then hand over the floor to our moderator for today, in the person of Raymond Ofagbo. Thank you all for joining us again. Raymond, over to you.
Thank you very much, Mrs. Ibuku. Good morning, everyone, from wherever you're joining us, if it's morning or if it's afternoon. I hope your day has gotten off to a great start. Thank you very much for registering and joining this, what promises to be a very insightful webinar. As Mrs. Ibuku has introduced, the theme for this year's annual ITPG webinar is Incoterms and international trade, navigating risk, responsibility, and cost in cross-border transactions. In delineating the respective obligations of buyers and sellers, allocating risk, the risks of loss or damage, delivery, ensuring that both parties are certain as to when each party is responsible for goods that are in transit in international trade is usually a very challenging issue. This issue has been existing for a long time, as far back as when trade started in the 17th century, 18th century. These are issues that the experts that do trade have been grappling with. And the International Chamber of Commerce in 1936 provided what was essentially a good first attempt at resolving the issue. They introduced what is known as international commercial terms, or for short, Incoterms, in 1936. These rules were designed to establish a unified framework for the interpretation of common trade terms in international contracts. Over the years, these rules have evolved. So it's not the original Incoterms that were drafted in 1936 that we use today. In fact, the ICC periodically updates the rules after a period of about 10 years. And the most recent iteration is the Incoterms 2020. Like I said, it's a good attempt at resolving this very critical issue. But for those of us that are in practice and use Incoterms regularly, we know that it is not yet, Uhuru, we do not yet have a fix-all. So even though Incoterms 2020 provides a comprehensive structure for the allocation of risk, responsibility, and cost between contracting parties, stakeholders still continue to encounter difficulties in documenting high-stake international transactions. And we've seen recent examples of multi-million-dollar trade deals embroiled in litigation because of some uncertainty with regarding to responsibility, risk, and costs. Now, today we've assembled a high-powered panel of professionals who have participated in international trade, who have also advised the institutions that implement the framework for international trade globally, whether it is transportation, supply chain, the contracts themselves. These are seasoned experts that have done this for a long time, and they have agreed to share with us this morning just a little bit of their experience so that all of us are better informed on the issues and would have a basis for doing further research. So I would briefly go through the format for the webinar. As you can see, we're trying to keep to time. We started at 11 on the dot, and we are going to have very high-powered, high-level presentations by the three speakers. Interspersed between each presentation would be poll questions. We encourage you to interact with those poll questions. We also encourage you to use the Q&A box. If at any point during the presentation, anything that the speaker says piques your interest or suggests to you that there is the need for more clarification on the concept, or if you've had an experience and you would like the speakers to address your experience specifically, please type in the Q&A box your questions, and towards the end of the webinar, I will come round to those questions and have the panelists do justice to those questions. Even if we get questions towards the end or even subsequently after the webinar, we would make sure that our panelists provide some form of responses to those questions, and we will circulate the answers to everybody that has participated in this webinar. So I know you're not here to listen to me, you're here to listen to the speakers. So without further ado, I'm going to introduce the first speaker, Dr. Ayemibo. Dr. Ayemibo is a man whose his experience precedes him. He doesn't need too much of an introduction. He's in fact a member of the ICC Commission. Remember I said the ICC are responsible for the introduction of Incoterms. So he's a member of the ICC Commission on Customs and Trade Facilitation and participates in the ICC Working Group on Trade Digitization and Blockchain. He is also the lead consultant and CEO of Treaty Impex Consulting, which is a leading international trade consulting firm, where he provides expert advisory services on international trade and international business development. Dr. Ayemibo is very grounded in international trade because from the academic standpoint, he also holds a master's degree in international business law from the prestigious Salford University in the United Kingdom, and he earned his PhD in international business and marketing from LIGS University in Hawaii in the USA. He's a renowned author and the AfCFTA ambassador. He hosts a weekly seminar series on the AfCFTA and conducts regular trainings on international trade finance. So, Dr. Ayemibo is going to take over from me now. He's going to be speaking on the topic, strategically allocating risk, costs, and delivery obligations in cross-border transactions using Incoterms 2020. Dr. Bamidele Ayemibo, please go ahead.
Thank you very much for having me. Kindly confirm you can hear me, please.
Yes, we can.
We
Please
can
go
hear
ahead.
you.
Oh, all right. Thank you very much. Thank you for having me. It's an honor to be here. And I'm speaking on behalf of the International Chamber of Commerce, Nigeria. I've been given the topic strategically allocating risk, cost, and delivery obligations in cross-border transactions using Incoterms. I want to take a look at this on the screen. This was a news August 3rd, and this was an incident of evergreen vessel. This is exactly what Incoterms is all about. You know, when the last speaker was talking, he talked about, you know, and I think about that also before 1933, before the first Incoterms came into being, how were we able to handle trade transactions? What exactly, how were they? I just imagine the kind of chaos they will have experienced. And that speaks to the work of ICC in putting together this rule and ensuring that ab initio, from the beginning to the end of a transaction, we are very clear as to our risk and obligations in the course of handling the transaction. Because in this case now, the vessel has issue, they have to jettison some containers, and because of that, whoever is owning those containers that are floating on the sea with those goods we need to ask the question, who is carrying the risk in transit? If there is no Incoterms, buyer will say the good have left the seller will say the good have left my country, buyer will say the good have not arrived, and you see the kind of confusion Incoterms create. Incoterms 2020 has to do with risk, cost, separate transaction risk and cost between buyer and seller in international trade transactions. That's define it that way. Incoterms separate transaction risk and cost between buyer and seller international trade transactions. So an importer and exporter can determine where their risk and responsibility ends. It has to do with risk of loss. It has to do with allocation of task. It has to do with cost allocation. It has to do with risk allocation. It has to do with transport cost, damage transfer, and responsibility. As long as the good is in transit, it's neither with the buyer nor with the seller, but who is responsible as the good moves from one location to the other. So how does Incoterms define risk and responsibility? Risk of loss or damage transfer. This is the most crucial aspect. It defines when liability for damages or loss to the goods shift from the seller to the buyer. This point is often, this point is often, but not always, where the cost also shift. Not always. So if you look at some Incoterms, if you look at FOB, for example, the risk and cost end at the same point. The risk and cost end when the good is on board the vessel at the same point. But when you are looking at CFR, for example, even though the risk end while the good is on board the vessel, the cost of transporting the good to destination is borne by the exporter. So the exporter is bearing the cost of transporting the goods to the destination, but the risk is ending while the goods are loaded on board the vessel. So you have some Incoterms in which the risk and cost end at the same point. Things like X-Works, things like free carrier, things like free alongside ship, things like FOB. But when you get to CFR, CPT, CIP, you now see the divergence between where the risk end and where the cost end as responsibility of the exporter. Responsibility of tax transfer is specified which party is responsible for transportation, for custom clearance, for import and export custom clearance, arranging and paying for insurance, providing shipping documents. Cost allocation, transfer. It dictates which party pay for the various costs associated with the transport and delivery of goods up to the specified point. So that's why when you see Incoterms being written, let's say I'm selling good to someone and I'm quoting the price. I said the price of my good is, let's say I'm exporting cocoa, like we do from Nigeria, for example, to Germany. My price is $8,000 FOB Lagos, or $8,500 CFR Hamburg, $8,000 FOB Lagos. That means my risk and cost end in Lagos. But you notice CFR $8,500 CFR Hamburg, because I'm quoting the location where my cost end. That's the Hamburg port in Germany. And you see that my price also has gone up. And that's very important, because Incoterms always influence price because of the responsibility that the exporter will need to bear in the course of moving the goods to destination. Cost allocation transfer. It dictates which party pay for the various costs associated with the transport and delivery of goods up to the specified point. Now, there's some principles that are very important for you to know as far as Incoterms is concerned. Number one is the fact that it's voluntary and contractual in nature. Voluntary and contractual in nature. Number two, standardization of role and responsibility. So, and that is clearly defined. Number 3, transfer of risk, not title. The good title, transfer of title to the good is going to be based on the bill of lading. If you are dealing with a transport document like bill of lading, transfer of title to the good. And in some contract, even the buyer retains, the seller retains title to the good until the payment is made at destination. So the contract and the transport document, they like yes, and determine what happens to the title to the goods. But it's only transfer of risk. Number 4, independence of payment terms. Independent from payment terms. You know, sometimes people talk about payment term as if it's related. Payment term is not related. Payment term is not related. Payment term is not related. In as much as when you're quoting price, which has to do with payment, some people relate it with the letter of credit or bill for collection or other payment terms. It's entirely different. The fact that it's an FOB, in fact, and it's very important because some people believe FOB means they will pay me in Nigeria. And I hear that a lot from exporters. FOB means FOB has nothing to do with payment. It has to do with the risk and cost of the good ending when the good is on board the vessel at the port of loading. Suitability of transport mode. Incoterms tell us the transport mode. If I hear FAS, I know it must go by sea. If I hear FCA, I know it can be any mode of transport. Transport mode. Number 6, requirement for a name, place, or port. When you are naming the Incoterm, you must name the place or port alongside with the pricing because it helps us know where the cost of the exporter ends. Where will it transport the good up to? Number 7, neutrality or jurisdiction. Neutrality to jurisdiction and language. It's neutral jurisdiction and language. It's universal. And lastly, clear division of cost. I know where my cost ends and we know where the other parties start from. Let's look at the protocol to follow. Incoterms 2020 are globally recognized rules issued by International Chamber of Commerce. Remember, risk, who bear the risk of loss or damage, cost, who bear the transportation cost, insurance cost, and handling, and delivery obligation, who arrange and handle logistics and custom clearance. Now, first, and very important, strategic allocation of risk. Risk refer to the point in the transaction where the responsibility for goods transfer from seller to buyer. If it's Incoterms exports, risk transfer at seller premises. For FCA, risk transfer when the goods are handed to the carrier. In FOB, risk transfer at when the goods are loaded on the vessel. In DDP, risk transfer at destination point. Risk transfer at destination point. Strategic tip: exporters should prefer terms where risk transfer to minimal exposure, and the importer may favor terms where risk remain with the seller longer, especially for fragile and high value goods. So in allocating your risk and cost, it all depends on your situation and what you want to achieve. How about cost? And the cost include transportation, insurance, loading, unloading, documentation, and duties. Incoterms exports, seller pay for nothing beyond making good available, but the buyer pay for all costs from the seller's premises to the destination. For FOB, seller pay for inland transport, loading, duty, export duties, and buyer pay for sea freight, unloading, and import duties. In CIF, seller pay for freight plus insurance to the destination, and buyer pay for import duty and delivery. And DDP, seller pay for all costs to the buyer doorstep, and buyer pay for none before delivery. What's the strategic tip? Seller can offer DDP, deliver duty paid, and CIF, cost, insurance, and freight. If they can negotiate better freight, because I have good relation with the shipping line, I can negotiate better freight. You cannot negotiate better freight. I want to bear that cost of moving the good to destination. And then buyer can use FCA, free carrier, and FOB, free on board, to leverage their own logistics and network for freight forwarding. Strategic allocation of delivery location. This involves arranging transport, booking freight, handling cost clearance, and preparing documents. Incoterms FCA, seller responsibility, export clearance, delivered to the carrier. Buyer responsibility, paying transport, import clearance. FOB, seller responsibility, load good on board the vessel. Buyer responsibility, shipping custom and destination. DAP, seller responsibility, deliver to the good to a nameplate. Buyer responsibility, import clearance and unloading. But DDP, seller responsibility, all delivery and clearance activity, and buyer responsibility, only receive the goods. Strategic tips for exporters. Exporters unfamiliar with destination regulation should avoid DDP because that will require a lot of handling at destination as they may face compliance issues. Let the importer handle that. For importer, in difficult jurisdiction, can opt for DDP so that the seller handle all the complexity of delivery to destination. In Nigeria, for example, the big companies, particularly multinational, because of the issue of clearance in Nigeria, they will give DDP contract to their supplier, but if the supplier, because of Nigeria regulation, will use CFR or CPT to bring it in. But in delivering to the ultimate buyer, which is a multinational in Nigeria, they are going to be using, particularly in the oil sector, they are going to be using DDP. That means this Nigerian contractor is the one that will bring it from the source to destination, even though part of it involves the use of CFR because of Nigerian regulation. Decision-making framework. If you are a new exporter, use Incoterms like exports or FCA. Why? It minimizes sellers' risk and obligation. If you are an established exporter with logistic network, use Incoterms like CIF, TAP, or DDP. Why? It gives you control over freight and customer service. If you are a buyer with expertise of supplier of country, use Incoterms like FOB or FCA. Why? Reduces cost, minimize local control. If you are a buyer in remote or risky area, use Incoterms like DAP or DDP. Why? Because of transfer delivery burden. You're able to transfer delivery burden to the seller. Key consideration for strategic use. Mode of transport. FOB, CFR, CIF for C only. Use FCA, CPT, CIF, DPU and DDP and DPU mode for all modes. Knowledge and custom knowledge. If unsure about import regulation, avoid DDP as a seller. Avoid it as a seller. Insurance need. Only CIF and CIP require insurance. And in these two Incoterms, the exporter is bearing the cost of insurance. The exporter is bearing the cost of insurance. It is recommended by the Incoterms rule. Recommended because of the high risk of the road. ITT clause A should be used. So if you are doing CIP, you should go with ITT clause A. But if you are doing CIF, you can do ITT clause C because of the low risk of on sea, but high risk on road, high risk on rail. So if you are doing CIP, ITT clause, Institute clause, cargo clause A insurance, covering all risk. But you can use B or C if you are doing CIF. Need nameplate. Always specify the nameplate or port. And freight pricing. Seller can build freight and delivery margin into CIF and DDP price. Now, look at this framework, decision making. Do you want to minimize seller responsibility? If yes, use X works. If no, do you want seller to handle export formality only? If yes, use C, FOB, or by any mode, FTA. If no, do you want seller to handle freight too? By C without insurance, CFR. By C with insurance, CIF. By any mode without insurance, CPT. By any mode with insurance, CIP. Do you want seller to deliver to destination before unloading, DAP? Do you want seller to deliver destination after unloading, DPU? Deliver at place unloaded. You want to deliver destination, including import duty, then use deliver duty pay. Look at this in practice. In practice, X works the risk and cost of exporter earns at its location. FCA, the risk and cost of seller earns at a terminal in its own country. Free alongside ship, the risk and cost of seller earns while the goods are at the ship side, overlooking the ship. At the ship side, overlooking the ship. FOB, the risk and cost of seller earned while the goods are on board the vessel at the port of loading. CFR, look at this. You notice export, FTA, FOB, CFR, and FAS, the risk and cost earned at the same location, but look at CFR. In CFR, the risk earned while the goods are on board the vessel, but you bear the cost of destination as an exporter. In CIF, the risk earned while the goods are on board the vessel, but you bear the cost of transport and insurance to destination. You bear the cost of transport and insurance to destination. CPT. Just like CFR, my risk end at the terminal in my country, I bear the cost of transport to destination. CIP, my risk end at the terminal in my country, I bear the cost of transport and insurance to destination. DAP, my risk end at destination, and I'm bearing the cost of transport to destination. So DAP, DPU, and DDP is called destination Incoterms. Destination Incoterms. Because they are destination Incoterms, the risk and cost end at destination. But look at DPU, deliver at place unloaded. Please note, in DAP and DPU, I am not bearing the cost of clearing at destination, even though I'm bearing the risk and cost of delivery to destination. In DPU, deliver at place unloaded. I'm bearing the cost of delivery to destination. I'm bearing the risk to destination. I'm bearing the cost of unloading it from the truck into the warehouse of the buyer. I'm bearing the cost of unloading from the truck into the warehouse of the buyer. But look at DDP. I'm bearing the cost of delivery to destination. I'm bearing the cost of transport to destination. In addition to that, I'm bearing the cost of clearing the goods in my country and clearing it at destination. And hence the word deliver duty paid. Deliver duty paid. What Incoterms does not do. It's important to know what Incoterms does not do. Number one, Incoterms does not concern whether there is contract of sale at all. Number two, Incoterms is not concerned about the quality and specification of the goods. Number three, Incoterms is not concerned about the time, place, and method and currency. Because sometimes we talk and think of Incoterms as if it's a magic wand. It's not a magic wand. It's not a magic wand. It's not going to solve the problem of quality of the goods. It's not going to solve the problem. In fact, it's a separate contract within the contract. It's a separate contract within the contract. Incoterms is not concerned about the time, place, and method and currency of payment. That should have been entrenched in the contract. It's not concerned with the quality of the good. That should have been entrenched in the contract. Incoterms is not concerned about the remedy for breach of contract. That should have been in the contract as to arbitration and the like. Incoterms does not concern about the consequence of breach of contract. That should also be based on the law guiding the contract. Incoterms is not concerned about the effect of sanction of the contract. If there is a sanction on a nation and there is a breach, that will not is not concerned about Incoterms. Incoterms is not concerned about the imposition of tariff, about prohibition at destination. So it's important to have a good understanding of the limitation of Incoterms. Why is it important to ensure we do not misuse Incoterms and thinking it will cover what it's not covering? And that's the whole lesson of this conversation. Incoterms is not concerned about the force majeure and hardship. And Incoterms is not concerned about intellectual property rights and contract. As I close, I would like to stress the need for reasonable and regular investment in trade education, especially with respect to obligation of importer and exporter in a contract. Why is this necessary? It's necessary to avoid misunderstanding between trading partners on risk sharing. Misunderstanding between trading partners on risk sharing. In order to avoid misrepresentation between trading partners on cost sharing. Misrepresentation between partners on cost sharing. And lastly, to avoid misinformation between trading partners on the point of delivery. Thank you very much.
Thank you so much, Dr. Ayemibo. Such a powerful presentation. My key takeaways from it are, multiple takeaways, but the key ones, Incoterms are a contract within the contract. So that's something for us to ruminate on. They are not a separate contract, but they are a contract within and the international sales contract. And then also payment terms are different. That's something that a lot of people always conflate. So thank you very much for that presentation. And I love the way you started it with the evergreen case study. A lot of us see these international high-stake trade disputes play out on TV, and it looks like just another story But when you now understand some of these contractual and commercial nuances to it, it gives it a different flavor. And I like how practical you presented the different Incoterms. So where does your risks and where does your payment obligation arise, and how it can move depending on which Incoterm is chosen. So thank you very much for that presentation. At some point, we would have a few poll questions be displayed on the screen. So we encourage our participants to interact with those poll questions. And if you have any specific question that's not included in the polls, you want Dr. Ayemibo to shed more light on something else that he has said, please leave a comment or a question in the Q&A box. I see that we have over 100 people on the call right now, so it's a really packed webinar. We're trying to keep the time, so I will just move on to the next speaker. So when the IT guys are ready, they will display the poll question and you will see that on your screens. But one thing that Dr. Ayemibo said, particularly in the last part of his presentation, is that Incoterms are a contract within another contract, meaning that there is a larger contract, and you need to make sure that you do not think once you've chosen the right Incoterm that it covers everything. There are some limitations, like Dr. Ayemibo has pointed out, and which the next speaker is going to adumbrate on. The next speaker is a seasoned dispute resolution specialist. So he has seen so many of the type of disputes that arise in international trade contracts, particularly where you are doing cross-border trade with shipping or aviation as the preferred method of moving the goods. That's the supply chain methodology chosen is maritime or aviation. Rafiq Anammah is a senior associate in the Transportation, Dispute Resolution and Arbitration Practice Group at AELEX. He is currently the chairman of the NBA SBL Aviation Committee and a member of the Dispute Subcommittee of the Nigerian chapter of the Aviation Working Group. So you see, he wears many hats. He can advise on the transportation of the goods, and if a dispute arises, he can also advice on the disputes. He has represented several clients at various levels of Nigerian superior courts and has been involved in high-value transnational maritime disputes. He was recognized as a rising star in transportation and shipping by Legal 500 in 2021 and 2022, and also in 2024. He has garnered extensive experience advising international and local clients on transportation issues arising from cross-border trade in goods, and he also advises on other areas of aviation and maritime law. The poll questions are up now, so please interact with them. Feel free to select any of the options. We'll be thrilled to go through your responses at the end of the webinar. So the second speaker, Mr. Rafiq Anammah, is going to be speaking on the topic, understanding the limitations of using Incoterms in high-value international contracts. So just as the first speaker said, there are lots of limitations using Incoterms, and Rafiq is going to give us a quick presentation on some of those limitations. So Rafiq, once you're ready. We see your slides now. So.
Yeah. Okay, thank you, everyone. Thank you, Roman. I hope you can see my slide and you can hear me.
Yes, you can just switch it to presentation mode, and then we're willing to listen to you now.
Can you hear me? Can you see my screen?
Yes, good to go.
Okay. So, sorry. Okay, so good morning, everyone. I'll be speaking on the subtopic, understanding the limitations of using Incoterms in high-value international contracts. So as Mr. Ayemibo has said during his presentation, Incoterms has its own limitations. So it is a contract within a contract. It is not an all-encompassing contract, or it is not meant to supplant the main contract, which is your contract for the sale of the goods between the buyer and the seller. So usually what Incoterms, how it is applied is that it is incorporated into your main contract for it to be enforceable, except for some jurisdictions which allow or recognize Incoterms as a trade custom. So it can be inferred into the contract. But for starters, I'll start with going through or explaining what Incoterms are. I know the moderator during his introductory speech has already taken care of that, and Mr. Ayemibo also addressed that. But we need to understand that Incoterms are the standard trade terms often used in international or cross-border trade contracts. They define the delivery points where costs and risk are transferred from the seller to the buyer in international trade. Now, Incoterms mean international commercial terms, and they were developed by the ICC in 1936. That was the first version of the Incoterms. Now, the essence of the Incoterms is to provide uniformity and general acceptance of commercial contracts globally. That is the main essence of the Incoterms. And then also, what they do, you need to understand that also, that Incoterms deal specifically with transportation, delineation of risk, delegation of obligations, and then delineation of costs between the seller and the buyer. So that is their scope. Now, Incoterms are globally recognized and accepted in cross-border trade, and they regulate business transactions on the sale and purchase of goods at the international or global level. So because I am speaking on the topic, the limitations when you're dealing with high-value transactions, we also have to understand what high-value transactions are, or what a high-value transaction or contract could be. A high-value transaction is a significant financial activity that exceeds a specific threshold, such as large cash deposit or large property or good purchases. It can also be regarded as a transaction that is significantly higher than a person would normally undertake. Now, because high-value transactions deal with volume, so they are more susceptible to risks and complexities. And because of this susceptibility to risk and complexities, there is an increased risk of dispute arising during those transactions between the buyer and the seller and other ancillary parties that may be involved in that transaction. Now, how did Incoterms come about? The previous speakers have tried to explain this. They were developed by the ICC in 1936. That was when the first version was published. But before then, there have been the use of commercial terms before 1936. But because there were variations or misunderstandings or misconceptions about these terms in different jurisdictions, there was a need to bring or to unify their meanings and their connotations. So that was why the ICC took the pains to publish the Incoterms, to develop it in 1936. And over the years, Incoterms have undergone several revisions or updates. In 1953, with the rise of rail transportation, some new terms were incorporated into the Incoterms, so as to deal with rail or the increased popularity of rail transportation. And also in 1953, to address the misinterpretation of the 1936 and 1953 versions of Incoterms, 2 additional terms were also incorporated, which we have seen on the screen, the DAF and the DDP. Then, by 1974, because of the increased acceptance of air transport for the movement of cargo or goods globally, another version was published in 1974, which introduced the free on board airport. I don't think it's now applicable. In the 2020, you won't find it in 2020, you just have the free on board. Then by 1980, a new term was introduced also. So there was under revision, which is the free carrier. Then 1990, an update was also implemented in 1990, which was the 5th revision of the Incoterms. Then in 2000, another revision was undertaken. Then by 2010, there was an 8th revision, which consolidated what we know as the D group of rules of the Incoterms in 2010. Then by 2020, which is the current version of the Incoterms, the latest one, which the previous speaker had addressed, the current version was introduced in 2020, and this contains 11 terms or rules, which are on the screen, which are the X-Works, the free carrier, the free alongside ship, the free on board, carriage paid to, carriage and insurance paid to, cost and freight, cost insurance and freight, delivered at place, delivered duty paid, and delivered at place unloaded. So the implications or the applications, the allocations of risk under these rules have already been addressed in the previous by the previous speaker. So I will not go into detail in addressing them. So now, what is the purpose of Incoterms? Like I said initially, the primary purpose of Incoterms is to delineate obligation, risk, and cost in the process of transferring goods from the buyer to the seller. So what Incoterms does, when parties apply Incoterms or elect to incorporate Incoterms into their contract of sale, what they are simply saying is, from the outset, these are our risks, our obligations, and our costs as they are going to undertake. That is simply what they are saying or what they are doing by incorporating Incoterms into their contract. So from the outset, there is no misunderstanding, or there's not supposed to be a misunderstanding, because it is deemed that parties are supposed to understand what they are entering into. Then the second one is provide uniformity in the understanding and interpretation of contractual terms that govern cross-border trade. So because parties, when you say FOB here in Nigeria, FOB should also mean the same thing to a seller in Venezuela. If FOB is used and incorporated into the contract in the United States, it should also mean the same thing to the buyer in Nigeria. So there should be uniformity in the understanding and interpretation of those terms, so that parties are not confused as to their obligations or to their responsibilities under the contract. Then also, the purpose of Incoterms is also to help to minimize risk or disputes, or avoid disputes or minimize disputes entirely in the process of the transaction. So because oftentimes why there are disputes in transactions is because parties are not adding them, either from the outset or in the course of the contract. So if parties understand what their obligations are, what their rights and obligations are under the contract, under the specific Incoterms rule that they've elected to apply and incorporate to their contract, then the possibility of a dispute arising is avoided or minimized. So now, to the fulcrum of this subtopic, what are the limitations? The number one limitation of Incoterms is that they have a limited scope. They deal with a specific scope of a trade transaction, so that delivery of goods and the transfer of risk. Like I said, Incoterms do not and cannot supplant your contract of sale. They only complement the contract of sale. either by incorporation or if they can be inferred, depending on the jurisdiction, if they are treated as trade customs. So they do not represent, or they do not cover all the entire contractual scope or spectrum. So issues like payment method, dispute resolution mechanisms, termination of contract, product defects, all those are not dealt with or are not covered by the Incoterms rules. Incoterms rules simply, or Incoterms simply delineates risk, obligations, costs, and then also the transportation mode. Then the second limitation is that they do not address the issue of ownership and title transfer. And this is important because a buyer is presumed or oftentimes assumed that he has bought the goods. And so because of that, he has title or his ownership has passed to him. But Incoterms do not address that. Issues of title and ownership should be addressed in the contract of sale or by the legislation, the national legislation of the parties' jurisdictions. Those are the agreements or infrastructure that deal with ownership and title transfer, but not Incoterms. Incoterms does not say when property or title is transferred from the seller to the buyer. It does not delineate that. And it is also crucial. For instance, if there is a damage to the goods while on transit before delivery, and a buyer needs to sue, and if the specie of suit he wants to bring is such that his locus is determined by his title to the goods, if title has not passed, despite the fact that there is a contract of sale purported to have bought, he cannot sue because title has not passed to him. So issues of title have to be addressed in the contract of sale of the parties or as delineated by the legislation, relevant legislation governing that transaction. Then the third one is Incoterms do not address certain issues. Like I had said before, this is ancillary or incidental to the first issue. They do not address issues like payment methods, breach of contract remedies, product liability, dispute resolution mechanisms. This must be specified in separate contract clauses. So parties cannot rely on Incoterms for this to delineate this response or these terms or these rights obligations. They have to be specified in the contract of sale itself. Then misrepresentation. Now, this may appear contradictory because Incoterms ordinarily are supposed to provide uniformity and understanding between the parties. But because they are flexible, they can lead to misunderstandings and misinterpretation. Flexible in the sense that parties can on their own, they are not rigid, they can on their own elect on which part of the rule, which type of rule, or which of the Incoterms rules they apply to their transaction. So if parties are not ad idem as to the purport or the import of the route that they are choosing regarding their transaction, there can be misunderstandings or misinterpretation as to their responsibilities and obligations in that transaction, and this can lead to disputes. So this can lead to misallocation of costs, misallocation of risk. So parties, let me continue emphasizing, must be in agreement from the outset. They must understand the rules that they want to apply and what the rules imply. Now, the fifth Incoterm limitation is the unsuitability for special products. Because of the limited scope of Incoterms, they may be unsuitable for special products that require unique or special transportation, special handling protocols, or packaging, such as chemicals, pharmaceuticals. To avoid the misinterpretation of responsibilities, specific clauses should be inserted in the contract to address the product's special requirements. So if there are special products that need to be transported or that form the basis of the contract of sale, and there are unique requirements surrounding that product, such as special mode of transportation, special handling methods, and packaging, the person that is responsible to undertake those rules must be specified in the contract of sale. Incoterms does not specify that, or does not allow parties to specify that by the use of the rules. Parties have to do that in their contract of sale to allocate these responsibilities. Now, the sixth one is the impact of legal systems, of diverse legal systems. The interpretation and enforcement of Incoterms can be impacted by the law and regulations of different legal systems. Now, why this is very important is that Incoterms, yes, globally accepted and globally applied, but at times national legislations or domestic laws can also impact on how they are interpreted or how they are enforced. So parties must be aware of this. For instance, from my research, I've been able to discover that countries like, for instance, Brazil, Mexico, they prohibit the handling of clearing issues by foreign companies. So if you're using DDP, for instance, then that is a problem. Because that is a core obligation in DDP, when you're using the DDP rule. So that's a problem. So you must understand what the domestic legislation of the country, of the parties, say about the specific rule of Incoterms that you want to apply to your trade. Now, also for some countries, you don't need to incorporate Incoterms expressly in your contract documents. They are treated as trade. Some of them are treated as trade customs. So by implication, they are inferred into the contract. So if you're dealing with a country that does not have such, and then you assume that it will be implied into your contract and then incorporate it, then you cannot rely on it. So both parties have to understand what their domestic legislations say or provide concerning Incoterm rules. So that will help them to choose the appropriate Incoterm rule for their contract of sale. Now, also, another limitation is there may be differences in preference on applicable Incoterm rules between sellers and buyers, and this can potentially cause disputes. So parties can be at variance as to what they want to, the rule that they want to apply in their contract of sale. So these differences can potentially cause disputes if they are not addressed from the outset. So that entails that parties must understand what each rule entails. So when you understand what the rules entail, you would not know if they are suitable for your contract. If parties are not adding them, as to that, this can cause disputes or even potential logistic disruptions or delays in delivery of goods. So now to the recommendations. Recommendation number 1 is that parties must ensure that they choose the right Incoterm. That's one, that help them properly allocate obligations and risks. Because each Incoterm rule has its own risk and obligations that it allocates to parties. So parties must ensure that the risk and obligation that they are willing to undertake under the transactions are covered by the Incoterm rules that they are choosing for their transaction. Now, parties must ensure that they choose the right Incoterm rule that is appropriate for the transportation mode, because there are transportation mode specific terms like FAS, free alongside ship, FOB, free on board, cost and freight, cost insurance and freight, which are specific to water transport, while others are suitable for intermodal. So we have 11 of them under the 2020 rules, for instance. So these 4, if you're using water transportation as means of carriage, then you can use this. these 4. Then if they are in multimodal, you can use any of the 11. So you have to understand the kind of transportation mode that you want to use for your transaction, for the carriage of goods. That will also help you to know the Incoterm rule that you would apply in your contracts. Then second recommendation is that parties must communicate clearly by using detailed contract that state the chosen Incoterm and other relevant contract details. Then parties must avoid the use of ambiguous or vague terms. So if you're specifying, if you want the port of destination or destination to be a specific place, don't leave it open. Specify it, name it in the Incoterm. While incorporating, let it be named there. Don't leave it open. Let every contract, let every term be specific. Let there not be any vague or ambiguous term. Then ensure that each party understands its responsibilities under the contract. For instance, if the person that is the party that is responsible for insurance should know from the outset that it is responsible for insurance. Party that is responsible for transportation should know from the outset that it's responsible for transportation. Party that is responsible for customs duties payment should know from the outset. So all these things, if parties are able to understand this obligation from the outset by communicating clearly between themselves, then they can use Incoterms effectively. Then lastly, parties should also always specify the Incoterm year to prevent confusion with the other Incoterm versions. I have said before, there are about 9 or how many versions from 1998 to 2020. There are about 9 revisions and versions of Incoterms. So parties must specify which of the versions and the rule, not just the year, and the rule that is applicable to their contract. This would help to address some of the concerns or reduce the limitations that surround the use of Incoterms. So in conclusion, I want parties to a international contract of sale to take note of 3 very important things. One is that Incoterms does not cover the entire scope of your contracts. If there are other obligations, other rights and responsibilities that ought to be conferred, parties should do that in the contract of sale. Incoterms does not supplant the contract of sale. Secondly, parties must understand from the outset their responsibilities, their risk, and their costs, and then the transportation mode. So once these are understood from the outset, it helps for parties to choose the appropriate Incoterms to apply to their contract, and then to apply the Incoterm rule that they've chosen effectively. And this helps to reduce disputes and misunderstanding. Then thirdly, parties should also understand the domestic laws or national legislations of their respective jurisdictions. So they must understand how these laws or legislations impact on the Incoterm rule that they have chosen for their transactions. This provides better clarity and understanding between them. Thank you.
Mr. Anammah, thank you so much for that presentation. I said it's like we've been transported from this webinar to a courtroom, the way you were allocating different responsibilities and risks to the different parties and advising them on what to do to avoid disputes. What I found most interesting in your presentation, and thank you very much for outlining all of those limitations and the scope of Incoterms, because it's really the second part of the conversation. So the first part of the conversation is that Incoterms are available and it's so valuable for you to understand them and use them in your high value contracts. But the other side of it is you need to understand the limitations so that you are properly prepared just in case there is a dispute down the line. So what I found interesting was the catch-22 or catch-22 situation where one of the issues with using Incoterms is that you've used them to provide certainty, but the use of the wrong Incoterm or Incoterm that the parties do not properly understand can create the uncertainty in and of itself. So that's why this type of conversations are very important, where experts such as yourself, Mr. Altaf, and Dr. Ayemibo, who have encountered a lot of these issues in their professional life, can advise people and say, look, these are the pitfalls, these are the things to watch out for, these are the red flags. So the next poll is up. I encourage our participants to interact with that poll. I see that we've gotten some questions in the Q&A box, so thank you for that. It shows that there has been a high level of concentration and participation with the presentations we've heard so far. And we've saved the nicest presentation, if I can say so myself. Mr. Altaf is joining us. It's really early where he is. Let me just say really early where he is. Well, he has joined us this morning to shed more light on a very interesting topic, which is the impact of Incoterms on international trade, compliance, and supply chain. So the challenges and prospects. So we're widening things up a little bit just to look at the issue from an international perspective, supply chain, the other side of the trade when we, as Nigerians, are trading with overseas partners. What are the key issues that we should pay attention to ensure that we are in compliance with international trade rules and regulations, and we're in compliance with the regulations that would apply at the port of destination of those goods. Mr. Altaf needs no elaborate introduction, because when it comes to international trade, he participates personally. He's a procurement and contracts lead at DRA Global, an international multidisciplinary engineering, project delivery, and operations management group based in Ontario, Canada. His primary focus is on mining, minerals, and metals industry, but he has a solid grasp of trading in different types of commodities and issues that are pertinent to Incoterms and supply chain globally. He's a seasoned procurement specialist with a wealth of experience in supply chain optimization, contract negotiation, and supplier management in cross-border trade. I'm really looking forward to listening to his presentation. And Mr. Altaf, if you can just give us a hint, everything is becoming digital with AI and all of that. So please, once we are ready, we're waiting for your presentation with bated breath.
Excellent. Yeah. Thank you for the kind introduction, Raymond. Yeah. You guys hear me okay, right?
Yes, we do.
Yeah. So let me share my presentation. Tell me when you can see it. I think you see it, right?
Yes, we do.
Yeah.
See it.
Yeah. So thanks again for inviting me for the presentation for this event. I think there's gonna be a little bit of overlap between my presentation and Dr. Ayemibo's and Mr. Anammah's as well, but I hope it's complementary and not too repetitive. So we'll try our best. That's the onus of being last in an event like this. But here we go. So the title is Impact of Incoterms on International Trade, Compliance, and Supply Chain. And like I said, there's a lot of different aspects to this, some of which have been already brilliantly presented by our, my fellow panelists here today. But I hope I can add to what they said and not repeat myself. So, and I found, to start off, I found this interesting phrase here. I don't know the source. I don't know who created this or who coined this phrase, but I think it sums it up quite well. Incoterms are like prenups for cargo. You know who's responsible before the honeymoon goes overseas. So it kind of defines roles and responsibilities and risks from the onset, right? I thought it was an interesting parallel. In terms of the agenda for today, we'll go over again what Incoterms are, their impact on trade, compliance, supply chain, a few challenges with sanctions, tariffs, and particularly, you know, AELEX is a legal firm. So what are some legal practice considerations that we should take into account when dealing with international trade? Some common mistakes and misconceptions. There's going to be a few practical examples along the way, and we'll finish with the future outlook and the revisions that are coming in a few years, right? So what exactly are Incoterms? It's been talked about before in the other presentations, but they were created in 1936 with the intention of providing a globally recognized set of rules for interpreting common trade terms to reduce misunderstandings in international transactions. Ultimately, it clarifies buyers and sellers' responsibilities, risks, cost, who's going to do what in every step of the transportation from the origin at the factory until its final destination. And of course, as you know, it has a few groups, E, F, C, and D. E is Ex Works, of course. F is for free. Cost is who's paying for what, and D is delivered. So the seller carries the cost and risk to destination. They are a globally recognized standard for international trade, defined responsibilities, like I said, and understanding their impact on compliance and logistics and all aspects of a transaction is essential for trade practitioners. And that's why it's even more relevant today than it ever was before, as the rise of international trade came through, to understand those and to address these aspects. And like others have said, Incoterms have changed a lot through the years. The first one was in 1936, and you see here the revisions here, what each revision entails, 67, 76, 80, 1990, and so on. And we're ready now for 2030, which is coming through in a few years, right? These revisions are due to evolving trade practices in order to clarify ambiguities from the previous versions. They address globalization, compliance with different rules, new laws that come into place, and also they aim at simplifying and, you know, keeping only the relevant terms in each edition, right? And in terms of visual representation, I find that this is very useful. There's a few sources and different ways to represent Incoterms. This is one of my favorites here. And as Dr. Ayemibo mentioned, for example, the risk transfer does not necessarily match when the seller's obligation switches to the buyer's obligation. You see here, this symbol here is meant to identify the transfer of risk. Sometimes the seller has it, and of course it still it still has an obligation. Sometimes it's after. There's still different risks here allocated. So I would highly recommend, if you work with international trade, have a graph like this printed and stored somewhere in your desk, because it's useful to always consult and to verify, right? When it comes to the impact on trade, Incoterms aim at clarifying costs and risk allocation. It tries to avoid contract ambiguity, and it's even more relevant today as incidents start to occur. A clear example of that, I don't know if you remember this, but this was like right in the heart of COVID, where the Suez Canal was blocked by one vessel. So the boat was stuck in there, and it took a few days or weeks to be freed and released. So what happens with the cargo at that time, right? Who's responsible? Whose risk it is or whose responsibility it is to keep the integrity of that cargo, right? One Nigerian example that I saw recently, as recent as April, the Lagos port congestion it affects DDP shipments. Of course, there's the merge cost, There's the damage to goods. Sometimes, you might be carrying perishable goods that will perish while they're stuck on a vessel, right? So who holds the risk? Who holds the cost? Who's responsible for remediating that situation, or who's responsible to interfere to release the cargo and so on? This graph right here is aimed at clarifying that responsibility. Okay. When it comes to compliance, what Incoterms try to do is to clarify the legal liability in these cross-border transactions, tries or aims at minimizing custom delays and disputes, and well, wherever possible, it tries to align with the destination's import-export procedures and compliances. One risk that I saw, and I think it was mentioned before by one of the panelists, misuse of DDP, right? If you specify or if you negotiate and agree on a DDP Incoterm for a contract, you have to be sure that the seller has enough clearance. It has all that it takes to clear the goods at the port and to bring it to its final destination, to pay all the relevant taxes at the country of destination, right? If not, it can lead to disastrous consequences or disastrous circumstances where, you promise something, or if you're a seller, you promise something to your client, but you cannot deliver, right? That can lead to delays, ultimately damaging the goods, and additional costs. When it comes to the impact on supply chain, and that is my area of expertise, that's where I've been acting since 2005 at least. When you specify the Incoterm, you define the point of risk and the cost transfer, right? It helps you to structure the logistics, the insurance, freight planning, who's responsible for freight, who's going to be responsible for all taxes and duties during the whole step of bringing the goods from the factory to its final destination. It enables clear negotiations in any sector, regardless of, if it's mining, oil and gas, whatever transaction, whatever line of business, Incoterms are applicable. And I must say that try as you might, on certain markets and transactions, Incoterms are dictated by the seller. For example, I just finished a project in Serbia where the aim was to have everything DDP Serbia, but like almost the totality of the bidders that we consulted, or the companies that we consulted, said, well, we do not transfer to Serbia. I don't have a contract with a logistics company. So the best thing I can do is free on board or Ex Works, right? So you might aim at having a certain Incoterm in a contract, but it's ultimately is market dictated, right? When it comes to sanctions, here's what Incoterms can help you mitigate, and here's what it cannot, right? Ultimately, it defines who's responsible for obtaining all the licenses and other regulatory documentations, and that's typically under Ex Works, FCA, DDP, etc. It helps to allocate the responsibility to ensure that goods are not being shipped to a sanctioned party or destination. But what it does not do is they do not protect, it's not an overarching protection from either party to violate the sanctions. The legal liability for these sanctions or for sanction breaches, it lies on the party that causes or facilitates the violation, regardless of Incoterms. So that's why legal is a fundamental part in every transaction. I would strongly encourage to have legal review every contract that your company gets into, because ultimately it's a risk mitigating practice, right? So one practical example that I could mention is if a Nigerian seller uses export logos, the buyer for some reason reroutes the goods to a sanctioned country, Iran, North Korea, the seller might be legally insulated only if they had no knowledge and fulfilled all legal duties under Ex Works, right? And one risk that we could identify is under DDP, the seller might be responsible for delivery all the way to the destination, including export, import permits, and customs clearance. This creates a high sanction risk, especially when the buyer is in the jurisdiction under embargo or secondary sanctions. For example, if you're buying goods from Venezuela, from Russia, from Belarus, Sudan, at the moment, you have to be sure as a buyer that your seller has all the clearance to bring the goods to its final destination, right? Otherwise, you might be not in trouble under the law. You're not the one causing breaching the sanction, but you might not have the goods in the time that you wanted them to arrive in your final destination, right? When it comes to tariff, that's a hot topic right now, especially with Mr. Trump waking up every day and thinking of a new tariff. Right or wrong, that's what he does, right? So Incoterms, they do influence the tariff responsibility. When you specify or when you agree on DDP, for example, the seller assumes all costs, including import duties and tariffs, and this exposes the seller to the risk of sudden changes in tariffs, right? The project I mentioned in Serbia, for example, I think that's what they were trying to avoid. Serbia is a hot mess right now. It's supporting Russia in the Ukraine war, so they are, chances are that one day you wake up and boom, that country is sanctioned. So that responsibility, if it happens that a country is sanctioned and the agreed Incoterm is DDP, right off the bat, the seller is responsible for a sudden change in tariff, right? So using Ex Works or FCA, in this case, it shifts responsibility for import tariffs and customs duties to the buyer. But they do not, what Incoterms do not do is they not specify the tariff rate. I think Dr. Ayemibo mentioned that, but yeah, it specifies the responsibility, but it does not specify the rate. Tariff clarification, valuation, and country of origin are determined by customs authorities, not by Incoterms, right? And that being said, the incorrect use of Incoterms in shipping documents can lead to misapplication of duties or compliance delays, and it might cause additional taxes or fines. That when that happens, it's anyone's game or anyone's guess who's going to be liable for it. Yes, Incoterms will help you define that, but if in the case of an exception, it's almost like you're back to ground zero in a negotiation, right? One key example, one example in the Nigerian context, for example, a seller using DDP Lagos without full knowledge of Nigerian customs tariff or harmonized codes or some cap requirements could face unexpected costs and clearance delays. I think under the law right now, if you export to Nigeria and it's DDP, the seller has to have a legal entity in country in order to be able to clear the goods at the port. And you need to be aligned with local tariff laws and so on, right? A few mistakes or pitfalls when specifying Incoterms. I selected 5 here. I won't spend too much into that, but so for example, when you specify free on board for air or multimodal shipments, that's the wrong one. And it can invalidate delivery point and risk transfer. For that one, for air or multimodal, the best one to be picked is FCA. Like I said in the previous slide, using DDP where the seller cannot import or cannot legally clear the goods or duties in the destination country. If the buyer handles customs, the best thing or the advised Incoterm to be used is DAP, right? A third one, using Ex Works in cross-border trade when the buyer often cannot handle export clearance under the local law. So best bet, again, is to use FCA seller's premises, right? CIF or CIF or CFR for containerized cargo, that's the wrong delivery point assumption. Possibly there's going to be insurance gaps when specifying that. So the best bet is to use CIP, CPT for containers. And the last one that I've seen many times, no location specified, is when, I don't know if you've seen this in contracts, but it says Incoterms, DDP, period. It doesn't say DDP where. So good practice here, or the right practice, is to always specify DDP and the place, right? And specify Incoterms 2020, just to be clear and to be safe. And as we are seeing in all 3 presentations and in my examples here, specifying and choosing the right Incoterm is, it should take into account a number of factors. It should take the negotiation that was done, use your tax expert for that, use your legal advice for that. So it's not one discipline that can control and can have the say on which Incoterm to use. And also discuss with your vendor, right? Because you might agree on the perfect Incoterm for that sale, but if the vendor cannot comply with the regulation, you back to square one, right? A few legal practice considerations that we can mention. With legal coming into place, we should ensure that contracts using DDP or DAP, for example, include force majeure or price adjustment clauses to address sudden sanctions or tariff hikes. One thing I would advise is conduct sanction screening, even if using XWorks or FOB, especially under the law of US, UK, or EU export control frameworks. Looking for sanctions or looking for your integrity, doing your integrity due diligence at every purchase is key to avoid pitfalls. One key term that I've been using is subject to applicable sanctions language when drafting the contracts. So that specifies that if new sanctions arise or new tariffs arise, we're going to negotiate that. So that's kind of a risk mitigation for both parties. Wherever possible, you should train clients, not just clients, train also your vendors on appropriate Incoterm selection. I find that it's like a sanity check that helps both sides of the equation. Always review the contracts for the correct legal implications. Aligning Incoterms with the local regulations, the Nigeria example that I mentioned, if you don't have a local company that is able to do customs clearance, specifying DDP can lead to risks. And monitor developments and new changes. Like I said, the Incoterms 2030, the discussions are ongoing right now, and I don't know if it's going to be implemented in 2030 or if it's going to come earlier in the game. I think earlier, right? A few considerations and a few things that we're expecting to change for Incoterms 2030. Of course, there's always some gray area. There's always some confusion that come, as trade occurs. So there's going to be changes to that, to the 2021 based on confusion in that legislation. Digitization will be central. So you guys know this, we don't print contracts to sign anymore. It's all signed digitally. Just an example of how we've moved to the digitized world. Here I am in Toronto speaking to a lot of listeners in Africa, which is great. So yes, that's going to be key and even more prevalent in new legislations. There will be, of course, a growing importance of ESG and transparency all the way through the supply chain, and that's going to be addressed as well. One key thing, the rise of Amazon and all these other e-commerce vendors, it's going definitely to address e-commerce, small parcel trade, returns and so on. Of course, there's always the shifting geopolitical and sanctions risk that's going to be addressed, with the war in Ukraine, the war now in Gaza, and so on. There's definitely a need for more legislation, more clarity in the Incoterms due to that. And of course, there's going to be new and/or retired terms, right? So that's a bit of a snapshot of what to expect for Incoterms in 2030. My final slide is some key takeaways on Incoterms compliance and supply chain is Incoterms go beyond contract clauses. They shape real-world cost, risk, and responsibility, and that's especially relevant in complex supply chains where you receive goods from multiple parts of the planet. Compliance risk, it lives in the execution of a contract. DDP, XWorks, and other terms, they define who handles customs, duties, risks, and sanctions-related obligations, not if they exist, right? When it comes to Nigeria, like I said, and I tried to come up with examples for the region, It presents unique challenges, for example, the local port congestions, some cap regulations, and sometimes inconsistent application. That makes using the correct Incoterms and using Incoterms correctly even more essential. And like, as I mentioned, legal advisors must bridge this gap. Your role is not just risk allocation, is helping the clients and vendors to align legal terms with practical realities. And the last but not least, Incoterms 2030 is coming, and it's now time to embed these terms in all contract templates, digital systems, and client strategies. With that, I close my presentation. I welcome any questions. And once again, thank you so very much for inviting me to this panel. I'm really happy to be here and happy to exchange experiences with you all. Thank you.
Where to begin? Rodrigo, you packed so much into your slides. Thank you so much. And I like how right out of the gate, you left me with something very, very pithy. So Incoterms are the prenup here, and it's
Yes.
good to settle that before the contract goes overseas for honeymoon.
Yeah.
Otherwise, it's not going to be a nice honeymoon if if the wrong Incoterms are selected.
It doesn't avoid all problems, but it tries to help, right?
Yes, it's best to have it. It's a good to have.
Yeah.
And and I also wanted to share that the part where you spoke about specific issues that apply to Nigeria and the congestion at the Lagos port. It's an issue that we've had to advise many clients on, or some clients on, and it's an issue that if you've not had hands-on experience on, it's difficult for you to contemplate. So 40-foot container that you send to Ghana, that's our neighbor, to clear that container in Ghana would probably cost you maybe $15,000. And just next door in Nigeria, it will cost you at least 10 times that. So if you are shipping from Europe to West Africa and you use exactly the same pricing framework and Incoterm to ship to Ghana and Nigeria, because both countries are next to each other, you're going to run into a pricing risk, because clearing that container in Nigeria is significantly more expensive. The processing timelines are also very notorious. So we recently went to the marina where you can see a lot of the ships coming into port, and there is a long line of ships waiting to come into the Lagos port to be cleared. And you would think that it should take the same amount of time that it takes to clear a ship in any other country in Lagos. It takes significantly longer. In fact, some people have reported that the time it took the ship to leave a port in Europe and arrive at Lagos was less than the amount of time it took the ship to get into port and get cleared. So it's really insightful to see the way some of these things can play out in practice, and how you need to be anticipatory, because like you mentioned, the sanctions against Russia and how that is affecting Serbia. Those are things that you may not be able to anticipate because we don't know which countries will be sanctioned next year. And if you have some contracts that have not been that have not run their course by this time next year, and then new sanctions have been put in place, you want to make sure that you adequately included language like what you suggested, subject to any sanctions. You want to make sure you have those in your contract, just to minimize your risk. And that's another thing you said that I liked. You can't 100% avoid risk, but you can do your best to minimize it. And speaking to experts like yourself, like Mr. Anammah and Dr. Ayemibo, speaking to those type of experts is a very good place to start if you want to anticipate the risk and make sure that you don't run into trouble when you're doing international trade. So thank you very much for that presentation. All three speakers have done exceedingly well with the source material that we give them. So we just give you a little topic and you've created this labyrinth of information. And I'm sure our listeners are packed full. We have quite a few questions. We would go through those questions and then we would reveal the outcome of the polls that we've had. We are running on schedule, so I'll advise the speakers. I know that some of these questions will require going a bit in depth to answer them. So just maybe 2-3 minutes on each question. I'll just address the questions to the specific persons that they've been addressed to, and then we'll take it from there. So the first question I have is addressed to Mr. Altaf, and it's from an Achike Umuna. So this is a practical one. So he says he has noticed to his dismay that most foreign traders will sign a contract stating that the term is Incoterms. Whilst opening the letters of credit, the entire terms are altered, excluding same vital clauses. This is weighted strongly against the Nigerian exporter who finally gets into the trap of his produce getting seized upon arrival at the port of delivery. So this person probably has a practical experience where the Incoterms were stated and then the letters of credit had different terms that didn't include the Incoterms. And when the goods got to their destination ports, they were seized upon arrival with the Nigerian exporter bearing all of the risk. So, Mr. Altaf, do you want to comment on this?
Yeah, I think I mentioned one of the mistakes that I've seen is DDP, right? The example that the question came up with is even worse. It's like Incoterms, right? Which are they? I don't know. So when that happens, I think it's you're put in a very bad spot if you're the buyer because you want the goods. You want them delivered to your factory or wherever it is to use the goods to in your business. But at the same time, there's all this uncertainty going on. Uncertainty gives leverage to the other side, right? So I would say that in whatever negotiation, whatever contract, specify what you want. Don't be afraid to be repetitive when you're specifying that and make sure that everything is lined up, because otherwise it's additional costs to your company. It's more time that you lose without having the goods for you. And when something like that happens, it's anyone's game and anyone's guess who's gonna, be in a better spot or in a worse spot than when you first started. That's why it's, Incoterms define the responsibility from the get-go. Studying that, making yourself aware of, the most current Incoterm legislation can only save you trouble. So that would be my recommendation. I don't know the specifics of the example of the question, but it sounds like a mess.
Yes, it does sound like a mess. Yeah. So thank you very much for that comment. So I'll just go on to the next question. The next question is for Dr. Ayemibo. Dayo Akinduntire is asking Dr. Ayemibo, if Incoterms is a contract within the contract, what is the best advice for a buyer and seller to avoid unnecessary conflicts? So I know Dr. Ayemibo gave a lot of advice. So maybe you can just zoom in on something specific for Dayo Akinduntire to take away from this webinar.
It's so important. Can you hear me?
Yes, we can.
Okay, so it's so important to first of all identify, since you assume you are in Nigeria, if it's an import transaction, you are the importer, you are restricted to 2 Incoterms. You can only do CFR or CPT if you are doing import. And if you are doing import, that means you are restricted to Incoterms, so you have to walk around those Incoterms. So if you are going by road or by air, you use CPT. If you are going by sea, you use CFR. But if you are doing export, you have options. All the options are available. All the 11 Incoterm options are available. You now have to determine, number one, in Nigeria, what I observe, I'm an exporter, and what I observe in most export from Nigeria is people prefer to do FOB for obvious reasons. Now, if they do CFR or CIF, number one, their cost goes up. Number two, they have to source for foreign exchange. Now, in sourcing for foreign exchange, you have to go and buy in parallel market most of the time if you don't have. And even when you have, because of the regulation of CBN, which people are really contesting right now, in which CBN say you must repatriate and you must sell in the NAFEM or in the foreign exchange market, official foreign exchange market, that means even when you have Forex and you won't be able to pay for your freight. And in Nigeria, because it's the guy has an offshore service, the shipping line will ask you to pay in Forex. So you pay in dollars or euros, depending on the shipping line. So I do MSC most of the time, and I have to pay MSC in Euro. For shipment, I do to Europe on MSC shipping line. Now, that means you have to go and buy FX. In fact, some shipping line will tell you, you can't deposit that FX into your account. It must be an inflow coming in. That means you have to find a way to get that money to the account. I'm basically saying that if you're an exporter in Nigeria, an importer in Nigeria, you don't have a choice of the Incoterms to use. But if you're an exporter in Nigeria, you have a choice. However, you must be conscious of how you can minimize your cost by choosing FOB, and the fact that you have to go and source for FX to pay for freight if you are doing CFR or CIF. I hope that answered the question. Thank you.
Yes, it does, Dr. Ayemibo. Thank you for that very brief and packed answer. So it's some practical guidance there given to both importers and exporters. Like Dr. Ayemibo said during his presentation, and Mr. Altaf also hinted at, and even Rafiq also spoke about it, that the choice of Incoterm to be used can be a function of the circumstances. So who should be responsible for what? It could also be a legal regulatory issue. Just like Dr. Ayemibo has said, that if you are importing into Nigeria, the number of Incoterms that you can use are limited. When you're exporting to other countries, you should also try and find out if there is a similar limitation in those countries as well. So thank you very much for that answer, Dr. Ayemibo. The next question is directed to Mr. Anammah. Rafiq, Miriam Abdul Fattah is asking, are you saying that except parties incorporate terms of the Incoterms into their contracts, it is not binding? So please throw more light on that issue.
Okay. I think the first point to note is that Incoterms, for them to be binding on parties, they are contractual. You understand? So there are issues of contracts. So if parties do not agree on them, then they cannot be binding. So how do you incorporate? And for it to be binding, even after agreement, it must be incorporated either expressly into the contract, or it can be implied. For instance, if it has become from practice between the parties, constant practice and usage between them, it can now be implied that they've taken it as a custom, a trade custom. Then you can imply it into the contract. But the most important thing is parties must be aware. They must be ad idem. There must be a meeting of the mind as to the incorporation of Incoterms into their contract, either expressly or by conduct or custom or usage. That is very important. But if parties are not ad idem, it is not, parties are not aware, or if one of the parties is aware, but the other party is not aware, or had no notice, or had never had such dealings with the other party, that it can be regarded as customary between them, then it cannot be binding. It's also good to note that there are not mandatory laws. Incoterms are not mandatory laws that parties must comply with. They are mere recommendations by the ICC. So because they are mere recommendations, parties are advised to use them for uniformity and clarity in carrying out their obligations, their contractual obligations. So they must agree to it. If they don't agree to it, you cannot impose it on any of the parties if they don't agree to it. I think that's, I believe, answered that question.
Thank you so much, Rafiq. So I would come back to you, with a very similar question, but before I do that, I would like Mr. Altaf to comment on the next question. So the next question is from Abdul Kabir Suleiman. Says, good morning, thank you for the presentations. In the event of pandemic, such as COVID-19, what happens to the Incoterm where a party is not able to fulfill its obligation? So thank you. I'm directing this question to Mr. Altaf, because I'm sure you saw some interesting cases during COVID-19 that had this sort of issues.
Yeah. I mean, Incoterms, they set the rules from the start, but it's like a stepping stone for a negotiation. I think as Dr. Anammah mentioned, it's not a legal term. It's not a legal obligation. It's not a legislation. It's a definition of who's responsible for what, right? It's a way to define who's responsible for what. But I think COVID, it would fall under what we call force majeure. And in situations like that, and I think in a lot of situations, it's not one discipline that solves everything. It's legal involved, it's commercial, right? If like in certain contracts, if you enforce everything from a legal perspective, you end up choking your vendor and you ruin a partnership, right? So I would say Incoterms are a starting point for a negotiation, but ultimately reaching a conclusion for events like a pandemic, it's a combination of factors. It's a compromise. Let's not fool ourselves, right? It was an event that shook the entire planet. So in an event like that, what I usually ask is what is possible, what's desirable, and what can be achieved, right? When these things are together, it's a win-win because the seller can sell the goods, we can bring it into country, and problem solved. But it's not always clear-cut, and the pandemic was an event that shook the entire country. It's going to shake us for at least one more generation. It's force majeure for sure. I don't know if the other panelists want to add to that or comment, but that would be my take. Incoterms in that sense would be a startup of the negotiation, but it's not an all-encompassing body of work.
Okay, thank you very much. If Rafiq or Dr. Ayemibo want to comment, they can briefly.
Okay, like he said, it's not remember the definition, it's a term that separates transaction cost and risk between buyer and seller in international trade transaction. So COVID disrupted global supply chain. I am supposed to ship, let's imagine an exporter who is shipping to Nigeria. He is unable to ship. Not that he doesn't want to ship, he's unable to ship. It's not like he didn't do the shipment as expected, or he did the shipment and something went wrong while the good is in transit. He's not even able to ship in this respect, and as a result, he's unable to send the shipping document, which is why Incoterms is a contract within a contract. Your contract should have had clauses on force majeure that should have addressed this. So in Nigeria, for example, a number of transactions, because, nobody envisaged it, so documents will not be sent to Nigeria for them to clear the goods. So the goods arrive at the port and incurring demurrage. So as an exporter, you have the responsibility of paying for freight and sending documents so that the buyer can clear the goods. But in this case, it's unable to clear the goods, and the goods have arrived. So what do? They decide to release the shipping document to the shipping line and give the shipping line instruction to release the good based on teller's release for the good to be released at destination. In some cases, the good arrived, but they could not get shipping document to clear. Then the importer was able to get shipping guarantee and indemnity from the shipping line to allow the shipping line release the goods. They got the guarantee from the buyer to release the goods. So these are options that were explored and that should be explored to be able to solve the problem, particularly when the contract have not even made provision for that because it never envisaged it. But as far as the Incoterms is concerned, just as we said by other speakers, it is an advisory, it's a recommendation. If you incorporate it, it becomes I mean, whoever have, what's the name, that have defaulted become liable. But as far as an issue like Incoterms, like COVID-19 is concerned, you really have to find a way to solve the problem, not falling back on Incoterms, because Incoterms, again, will not solve that kind of problem. Thank you.
Yeah.
Okay, thank you very much for that. Reaction. Chineye Ezea Basili has some interesting questions. I will just direct first one to Rafiq. Says, good day, sir. Thank you so much for an insightful presentation. You mentioned that Incoterms used must be indicated. My question is, does this mean that the current Incoterms 2020 does not necessarily repeal the past ones? Does it mean parties can use Incoterms of previous years?
Okay, thank you. Just like I've said before, because they are not laws, so we are not talking about repealing. So what happens is that they are constantly updated. So when they're updated, what happens is that the older versions are retired, but not that they cannot be applied or used by parties. They are retired, but parties still have, because it's good to understand that these things are contractual. So when you enter into a contract, parties decide what they want to do with themselves, subject to legislations or mandatory legal rules. But these are advisories or recommendations. So parties can also use older versions, but it is recommended or it is advised that newer versions are used rather than the older versions, because why they are updated is because issues have been seen with the older versions, and to correct those issues or those problems that emanated from the older versions, so they are updated to the newer version. So newer versions are recommended to be used, but that does not mean that parties are stopped or prevented or prohibited from using the retired version. So they are not repealed. You can just say that they are retired, but still usable or applicable by parties to their contracts. Thank you.
Thank you, Rafiq, which is why the specific year should be mentioned. If you are using an older version, make sure you mention the year that you are using.
Exactly.
So another question that Chineye has left for us is directed to Mr. Rodrigo Altaf. So she says, thank you so much for your presentation. I appreciate how clear your presentation was. My question is in relation to the impact of Incoterms as it relates to compliance, where these terms are not adequately provided for in the contract, or if it were, it was wrongly applied. How can this be resolved or mitigated in such situation? Thank you so much once again.
I would say renegotiate, right? Nothing's preventing you from renegotiating halfway through a contract, right? Let me see here. I'm just looking for my slides on compliance. Yeah, so I think when it comes to compliance, it's clarifying the legal liability in cross-border transactions. If it's wrongly specified, you're in deep trouble, right? So renegotiate, and the same as the question of COVID, with the caveat that COVID was force majeure, right? But a similar scenario where you look at what can be achieved as opposed to what must be achieved, right? I think the primary goal is to bring your goods to the destination so that you can use the goods. So let's solve that and then deal with the liabilities as they come along, right? And when it comes to local authorities and compliance with the local regulations, always try to be transparent. I would say tell the truth and not try to hide anything. Be transparent, and even be transparent to say that this was not foreseen when we negotiated the contract, and try to deal with the authorities to the best of your ability. It does not mitigate, but it's a good starting point. I hope it answered your question. If you have a specific example, I'm more than happy to take it offline to discuss it.
Thank you very much, Rodrigo. So I'll just take the last 3 questions because we're really close to the allocated time for the webinar. And I'll just ask each of the speakers to comment in 1 minute on each of the questions I'll address to them. Then we'll look at the polls and then close with the brief remarks from Mrs. Popo. So the first one is from Rachel Adashiel. She's asking, is it okay to use a particular Incoterm, for instance, S-Works, and then switch responsibilities to say that the buyer shall perform the duties of the seller and vice versa? So quickly, Mr. Altaf, is it possible to have hybrid use of Incoterms? So you specify what the Incoterm is, but you modify it for your specific contracts.
Well, it's possible because, like the other panelists said, it's not, Incoterms are not a legislation, but I would avoid that because it does create confusion, right? But I would try to avoid. But if it's clear for both parties, if the drafting of the contract is clear as to which party has the obligation for each step, for each duty, and so on, yeah, go ahead, right?
Okay, thank you very much. Thank you. An anonymous question, I'll direct this to Rafiq. Says if the shipping is DDP or DDU, how does FOB, CRF, or CFR Incoterm affect the shipping contract? Rafiq, can you hear us? Okay, well, we'll wait for Rafiq to come back. Dr. Ayemibo, the last question, I guess you've already answered, but Great Madudi wants to know, are Incoterms like FIDIC standard form contracts in the construction industry?
Sorry, I didn't get that question.
Great Madudi is asking, are Incoterms like FIDIC standard form contracts in the construction industry? So, you know, if the construction industry, we have the red book, the silver book, just standard contracts that are used where the engineer is going to have specific responsibilities, whether it's a DBO, an EPC contract, whether it's going to be design and build only. So the specific form already allocates responsibility between the owner and the engineer. So they ask, this person wants to know if a parallel can be drawn between Incoterms for trade and standard form contracts in the construction industry.
Yes, because the goal of Incoterm is exactly what that standard form does. And it can be very flexible also, even though, like Altaf said, it can create confusion. But the responsibility can go both ways. And a typical example I like to use is CFR. You know, in CIF and CIP, responsibility of insurance is exporter. But in CFR and CPT, there's nobody. So meaning anybody can decide based on what the contract says. It can go that the exporter is the one bearing the insurance, the importer is the one bearing the insurance. And that can also apply in any of the Incoterms for you to be able to decide which of the one that you guys want to do. Because in some cases, even in Nigeria, when people are importing, even though Nigeria says CFR, meaning insurance regulations on the importer, and the government regulations say you must do that insurance locally. Some people still want to do it abroad themselves because they probably have issue with maybe the insurance company that they're going to use in Nigeria or in Africa, and they would rather want to deal with another company abroad. And in some cases, the exporter will have to do that instead of the importer doing it. So it's still an advice, it's still a recommendation, and both parties can decide which way they want to go. And you can actually draw a parallel between it and the standard form in a construction contract, because at the end of the day, it's what both parties agree that will eventually hold as far as transaction is concerned.
Okay, thank you so much. So what we're going to do next is thank everybody for contributing Q&As. We appreciate if you have any further need for clarification, if you send us an email. We'll make sure that those questions get to the speakers, and any answers that are provided we will share subsequently with attendees at the webinar. We'll also share copies of the slides that were presented today. I believe we have permission of Dr. Ayemibo and Mr. Altaf and Mr. Anammah to share their presentations. Yeah, okay, thank you very much. So I would invite my colleague to present the poll results. Thank you to everybody that participated in the poll. We would just like to see where the the majority see things are as respect to the topics that were discussed. So Abena, please, you can present.
Okay, thank you, everyone. Thank you to our panelists for an insightful discussion on Incoterms. So, my name is Abena Titilola. I'm an associate with the AELEX Accra office. And so we'll share the polls from our first subtopic, which was strategically allocating risk cost. So for the first question, when negotiating Incoterms, which factor most influences your preferred term? Most of our participants answered liability and risk management as the factor which most influences their preferred Incoterm to use in contracts. So yes, we had 71% of the participants who answered the poll questions choose liability and risk management. For the second question, which Incoterm do you or your clients use most often in practice? Most of the participants who answered the poll questions chose FOB, which is a well-known Incoterm. Then the last question from our first subtopic, do you consider the use of Incoterms as part of your risk mitigation strategy and contracts? We had 47% of our participants who answered the questions choose yes. We align it with insurance and logistics. So the use of Incoterms is part of your risk mitigation strategy because you align it with insurance and logistics planning. So that's the results from our first subtopic. So the next subtopic was limitation of Incoterms. So we'll share the results of that as well. So the first question, in your experience, what is the biggest limitation of relying solely on Incoterms in cross-border contracts? And we had 2 results on this with the highest. So we had a tie. So people chose disputes over interpretation, and they are often misused or misunderstood. So the biggest limitation is this, Incoterms are often misused and misunderstood. Then the next one, we also had a tie for that answer. Have you ever encountered a dispute due to a misunderstanding of Incoterms in a high-value contract? Most people said no. So as Incoterms are becoming increasingly popular, we will probably see an increase in disputes due to misunderstanding of Incoterms. So for the third question, for high-value deals, how do you typically handle obligations not addressed by Incoterms? And so this one, we had a resounding majority, separate clauses in the main contract. So they have separate clauses in the main contract to handle obligations which are not addressed by Incoterms, which ties back to the presentation by Mr. Anammah. So the last subtopic C, which was presented by Mr. Altaf, we'll share the results of that as well. Yes, so the first question was, how often do compliance issues, example, export controls, customs clearance, affect your choice of Incoterm? And a lot of people said frequently. So export controls do affect the type of Incoterm that you choose and you put in your contract. Then the second question, do you coordinate internally with legal, logistics, and finance when selecting Incoterms? A lot of participants said always. It's a cross-functional decision. And the last question, what is the biggest challenge your company faces when using Incoterms across different regions? And so the majority was aligning with local customs laws, which ties back to the presentation by Mr. Dr. Ayemibo, where if you are not familiar with your local customs laws, then you let the local handler handle the logistics in that aspect. So these are the results from the poll questions. Thank you.
Thank you, Abena, for giving us the results of the poll. I think we are now at the brink of time. Raymond, if there are no other comments, I'll just quickly say A very big thank you to our panelists. You delivered on your subtopics so well. We saw the engagement from the audience, who were also very rapt with attention and sustained the attendance from the beginning until the end. And this is very impressive. Knowledge has been shared, people have gained insights, and I have personally learned a couple of new information and ideas. So I'll say a very big thank you to all our panelists, our attendees, and the ITPG team for putting together this webinar. It's our commitment to continue to share thought leadership and knowledge in international trade. And we look forward to more opportunities of engaging like this in the future. And until then, thank you, everyone. We'll be in touch through our emails and regular newsletters. Do enjoy the rest of your day.
Thank you. Bye-bye.
Bye.
Thank you. Bye-bye.